Miss Carlson,
Yes.
yeah, go ahead. Please state your name for the record and let us know who you're with. Thank you.
Hello, Mr. Chairman and members of the committee. My name is Renee Carlson. I serve as General Counsel for True North Legal and regularly engage in matters pertaining to parental rights. I'm here today in support of Senate File 2909. Parents' rights to direct the education of their children does not end when a child goes to school. But is that true in Minnesota? History is telling. Over the last decade, state agencies and related subcommittees, as well as school boards and administrators, have created policies that undermine parental rights. Consider these few examples. Minnesota State High School League's decision to allow males to play on female sports teams, despite significant parent testimony opposing the board's changes. The Minnesota Department of Education's implementation of the transgender toolkit over much parent objection. The Public Educator Licensing Standards Board lack of transparency with regard to changing teacher licensing standards and cultural competency as statutorily defined. The practical implications of these decisions are policies that circumvent parental notice in matters relating to physical and emotional health, discipline students for acting consistent with various religious and moral upbringing, teach students about sexuality and how to obtain contraceptives without parental knowledge, and allow teachers to use curriculum that would be considered pornographic in any context outside of diverse literary content. Equally concerning are the decisions by courts across the country, including Minnesota courts, that infringe on the firmly established constitutionally protected rights of parents. Courts have long recognized the constitutional right and responsibility of parents over their minor children, especially in matters relating to their child's education and upbringing. Yet, schools in Minnesota have starkly departed from the U.S. Supreme Court's near 100-year precedent that the child is not the mere creature of the state. Those who nurture them and direct their destiny have the right, coupled with the high duty, to recognize and prepare them for additional obligations. That's a quote from the Supreme Court. Years later, in further recognition of this right, the Supreme Court observed that, quote, parents possess what a child lacks in maturity, experience, and capacity for judgment. Minnesota law also recognizes and upholds this long understood right of parents. Minnesota's regard for parental rights is clearly evidenced by one of the strongest educational opt-out laws in the country, as well as state statute that requires parental involvement in education. But the spirit and intent of the law has fallen on deaf ears in many places across the state, and these court decisions and the laws that we have now simply are not enough. Schools have continued to pass egregious policies inconsistent with clearly established Supreme Court precedent regarding the role of parents in the upbringing of their children. Unfortunately, the U.S. Constitution, the Minnesota Constitution, and the Supreme Court have become secondary resources for many decision makers interpreting parental rights laws in this state. This leads to policies that contradict the law, often marginalizing parents who do not champion a school's belief about gender confusion, implicit bias, general disparities, and sensitive family life issues. Even greater tensions exist when a school's actions directly contradict parents' moral teaching, often based on strong religious convictions. I assure you, members, that this bill is not based on hypotheticals, and the need for this bill is not based on simple anecdotes. In the last 2 weeks, I've received inquiries from parents representing 5 different school districts across the state, including a request from 50 parents representing over 100 students concerned about a policy that the school plans to adopt, which allows students to change their sex and determine their gender identity without parental consent if it is the school that determines that telling the parent would put the student at risk. Unfortunately, the school showed little regard, if any, for these parents' concerns, including Muslim parents who do not speak English, insisting the law requires the school to adopt this policy. You spoke of teachable moments. Well, how about this? Another parent informed me that her child's teacher shared matters about her personal sexual preferences during class and encouraged students in various forms of sexual experimentation. The parent's email to me said, and this drives the point home, I will drive clear across the country for help. I will do anything for my child. These are Minnesotan stories. They matter, and there are many more of them that I could share with you if we had a lot more time, but I'll finish here. Understandably, we know that schools face many complexities in our culture. Moreover, schools have a legitimate interest in the education, health, and safety of children that will one be adults in our society and in our great state. However, when schools decide to circumvent open meeting law, disallow or severely limit public comment, administrators will not return emails, and the Minnesota Department of Education, along with other educational organizations and school attorneys, counsel schools to implement policies that blatantly violate parental rights, the legislature needs to act. To be clear, legislation recognizing the supremacy of parental rights is not a partisan plot to micromanage schools and teachers. Such claims significantly devalue the commitment of parents to their children. Rather, this legislation is a response to the erosion of parental rights in our state and the current policies that only drive a wedge between parents and schools. Therefore, members, we strongly encourage this committee to pass legislation that restores rights to parents to decide what is best regarding their children's education and upbringing. Thank you.
Thank